Hello and welcome to Anglo Siam Legal. My name's John. I'm the Client Affairs Manager for the firm. I'm a practicing British and international lawyer and a member of the International Bar Association. My team here are in-house, qualified and regulated Thai lawyers, barristers, attorneys, consultants and accountants. All of our team are in-house and all work for the firm. So, a burning question that everybody keeps asking, whether it's on social media, whether it's on platforms, whether it's via email. What can a foreigner own and what can he can't? And how do they go about it? So we've all seen the social media, we've all seen the changes, we've all seen the crackdowns on nominee companies, etc. And a lot of people have entered into nominee companies that are holding villas, especially in places like Koh Phangan, Phuket, Samui, etc. But they also have them here in Pattaya and on the eastern seaboard. So let's break it down just very quickly as to what you can and cannot own. So as most of you will know, foreigners, except under very, very limited circumstances, cannot own land in Thailand. And when I say land, that is a plot of land, a field, etc. What we can own in foreign quota is a condominium. If the condominium is in foreign quota, then you can own that in your own name without a Thai person, without a Thai company, and you get your blue book. That's it. You're the owner, you're the title holder, your name's on everything. Easy. Where the difficulties come in is when people want to own houses and land. Like I said, foreigners can't own land. For many expats here, you're either living with or married to a Thai national. It becomes easier, but risky. The Thai national can, of course, hold land and own property in their name. And that's where we start. Can you hold it or can your partner hold it lawfully? So let's take it that you are man and wife and you've been together for a few years and you're now planning to buy some land, potentially in Pattaya or potentially in his or hers village, and to eventually build a house. What do you need to do? Well, the first thing is due diligence, because not all land has a title deed. Better title deeds, like a Chanote, which is the red one with a Garuda, that is your top title deed, and you can basically buy, sell, trade, build, loan against it, etc. But the further down the scale you go, the less rights you have. Now, there's some land, Sor Por Kor, which is government land, it's agricultural land, it's military land, it's forestry land. And whilst some Thai nationals and families have a right of occupation and they pay small taxes upon it, that land cannot be sold, traded, built upon officially, etc. And we do see many cases where foreign nationals will come and say, John, can you do me a lease or a usufruct or such and such for this? And we'll check the land and they then find out it's agricultural land. It doesn't have a title deed. You can't have anything registered against it. And they may have already spent 2 or 3 million building a house upon it. So due diligence is the first stage. If we pass the due diligence stage and the title deed is good, we have a look for encumbrances. Who owns the land? Is there any liens against it? Does it have mortgages or loans against it? Is there any current restrictions against it? Again, we advise upon it. If that then passes, we then move to the next stage. So then we look at how do you safeguard your investment. So let's go back to the married couple. You found the piece of land, we've done the due diligence, it has a good title deed, it's free from liens and mortgages and encumbrances, it can be bought, it can be built on. Great. You're going to invest 2, 3, 4, 10 million. Buying it, building on it. What are your rights? Quite simply, we would recommend the title deed is held in the Thai person's name, where it is mortgage free, because you're investing into it. You can place a mortgage or a loan on that title deed in your favour against the title holder. That prevents from sale or trade or borrowing. You can then choose, depending on your relationship status, but let's go for you're married, choose to have a usufruct. which is a lifelong registration so that you can have rights and management and live on the land and the property. Leases are generally for unmarried couples, but if you're unmarried, then you can enter into a 30-year only lease agreement. Again, similar things, right, use and enjoyment of the property. Now, if you're planning to build a house on the land, we would advise to get the planning permission registered in your name as the foreign national. Why? Because then you can register a right of superficies. In layman's terms, what that means is you own the house. You don't own the land, you own the house built upon the land. You then have the lease agreement or the superficies to combine the use and enjoyment of the land for the 30 years, but you own the structure and land itself. Again, it safeguards against borrowing, it safeguards against unwanted sale. Now, what a lot of people don't know is a newer act called a sapping sith. This came into force in 2019, just before COVID, but it's just gaining traction now, and we're promoting this to foreign nationals. A sapping sith is essentially a combination of your usufruct, your lease, and your superficies. Now, whilst it's more expensive to register at the land office, whilst it takes longer to register, it's a two-stage process, the title holder gets title, and you as the foreign national get your own sapping sith title, your own piece of paper with your name on it. That allows you to borrow or loan against that property or house, etc., in your own name. It is a great piece of paper and the strongest we think that you as a foreign national can have to protect your interests. Whichever one of those you choose, we also advise a memorandum of understanding between the two parties. Where is the finances coming from? What can it be used for? What happens if we get separated or divorced? What happens if I want to sell? What happens if this? What happens with that? Who can do this? Who can do that? It clearly defines legally what can and can't be done. And finally, last wills. You may wish to leave your lease, your sapping sith, your right of superficies to an heir. Do a last will. If a Thai person who owns the land doesn't do a will, it falls to line of succession. And unless you're married, you're not in that. You could have spent 20, 30, 40 million. You're not in that. If you're single and not married to a Thai, and they've got the land, you don't have a claim. As a married person, you have a claim at 50%, but 50% is then divided between the other family members who have a claim. Where does that leave you? Where does that leave your rights? So we complete due diligence, an advisory package to look at your individual circumstances, to say and to advise on what you can do, what you can't, how to safeguard it legally. And I've never mentioned a company in all of this. These are the legal ways that you as foreign nationals can use, live, enjoy, and protect your property in Thailand. It's easy. So I hope that's been beneficial. Again, share it to those who need to know. Share it to your friends who are looking to invest. Share it to the couples. Share it to the husbands and wives. Give us a thumbs up on Facebook. Follow our YouTube channel. We're here as our award-winning team to provide you, our clients, with expert guidance to safeguard your property in Thailand. Whether you're in Pattaya or the Eastern Seaboard, Chiang Rai, Isan, Phuket, it doesn't matter. Our legal and lawful solutions are there for you, and our team will make it happen. So for all of your legal needs and accounting, Anglo Legal, just by Big C, Pattaya Thai. Drop in, say hi, give us a call, drop us an email. We're here to help. I hope this has been clearer for a lot of people and gives you an insight into how to do things legally. It's what we're here for. Thanks again.